Those charges are still pending, and the defendants remain at large. But again, the special counsel's report did not find any evidence that members of the Trump campaign or anyone associated with the campaign conspired or coordinated with the Russian government in these hacking operations. In other words, there was no evidence of the Trump campaign collusion with the Russian government's hacking. The special counsel's investigation also examined Russian efforts to publish stolen emails and documents on the Internet. The special counsel found that after the GRU disseminated some of the stolen documents to entities that it controlled, DC Leaks and Guccifer 2, the GRU transferred some of the stolen materials to WikiLeaks for publication. WikiLeaks then made a series of document dumps. The special counsel also investigated whether any member or affiliate of the Trump campaign encouraged or otherwise played a role in these dissemination efforts. Under applicable law, publication of these types of material would not be criminal unless the publisher also participated in the underlying hacking conspiracy. Here, too, the special counsel's report did not find that any person associated with the Trump campaign illegally participated in the dissemination of the materials. Finally, the special counsel investigated a number of links or contacts between the Trump campaign officials and individuals connected with the Russian government during the 2016 presidential campaign. After reviewing these contacts, the special counsel did not find any conspiracy to violate U.S. law involving Russian-linked persons and any persons associated with the Trump campaign. So that's the bottom line. After nearly 2 years of investigation, thousands of subpoenas, hundreds of warrants, and witness interviews, the special counsel confirmed that the Russian government sponsored efforts to illegally interfere with the 2016 presidential election, but did not find that the Trump campaign or other Americans colluded in those efforts. After finding no underlying collusion with Russia, the special counsel's report goes on to consider whether certain actions of the president could amount to obstruction of the special counsel's investigation. As I addressed in my March 24th letter, the special counsel did not make a traditional prosecutorial judgment regarding this allegation. Instead, the report recounts 10 episodes involving the president and discusses potential legal theories for connecting those activities to the elements of an obstruction offense. After carefully reviewing the facts and legal theories outlined in the report, and in consultation with the Office of Legal Counsel and other department lawyers, the Deputy Attorney General and I concluded that the evidence developed by the special counsel is not sufficient to establish that the president committed an obstruction of justice offense. Although the Deputy Attorney General and I disagreed with some of the special counsel's legal theories and felt that some of the episodes examined did not amount to obstruction as a matter of law, we did not rely solely on that in making our decision. Instead, we accepted the special counsel's legal framework for purposes of our analysis and evaluated the evidence as presented by the special counsel in reaching our conclusions. In assessing the president's actions discussed in the report, it is important to bear in mind the context. President Trump faced an unprecedented situation. As he entered into office and sought to perform his responsibilities as president, federal agents and prosecutors were scrutinizing his conduct before and after taking office and the conduct of some of his associates. At the same time, there was relentless speculation in the news media about the president's personal culpability. Yet, as he said from the beginning, there was in fact no collusion.